3, 2, 1. This is Caroline Douglas. I'm author of The Dark Side. It's my latest law treatise. It's called A Law Treatise on Judging with Memra. In order to get ready to write this treatise, it's an 8-pound book. It's 1/3. It's a trilogy. I had to cut a lot of my book away in order to get it down to a mere 800 pages. Now, for a law book, that's pretty small. I think my other law books were like 1,800 pages. So I thought I had license, but I had no idea it would be so heavy. It's a heavy book in more ways than one. And sadly, it's a dark book. It started out with me trying to figure out why somebody who's a Girl Scout, a brownie, a do-gooder, a achiever, could end up disbarred. How could that happen? I mean, it's really crazy. I mean, to grow up in a place, in a time of your life when people were so proud to be Americans. Even after the Vietnam War, we were proud and we felt like we're world leaders. And now I look, you'll see the graph in here, the graph for incarceration for the number of Americans. We lead the world 4 times over. We beat out Rwanda. We incarcerate 4 times more people than Rwanda does on a percentage. You look at the worst civil rights countries on the globe, and we win. We have incarcerated so many men. Now we're doing women too, but we have incarcerated so many people because of public policy. And so I've ended up free-ranging in terms of public policy, because I think, and it's funny that my studies, I'll be right back, I'm not leaving. David Souter used to be my neighbor. He was a Supreme Court judge. I knew Anthony Scalia, had dinner with him. Tony Kennedy was my con law professor. I got in trouble even back then. Now we're talking about the Girl Scout that in a great big amphitheater kind of classroom sat in the front center seat, front row, across from Professor Kennedy, who was a federal judge at the time. And I was such a goody two-shoes, maybe a brown nose even, that the federal cases, the docket came out on Wednesdays, and my class was Wednesday night with Professor Kennedy. So I would go to the library and I would read everything that he just decided. And because I was a single mom working my way through law school, it was so hard to keep up. What I would do is these little yellow stickies. So I would open up my book, and every case that I read, I would put the name of it and a little 3-word sentence to remind me, and I'd have little yellow stickies all over all these pages to kind of cue me, so that I could raise my hand in class, and I thought he loved me. He loved calling on me. That day, when he came out with the affirmative action decision. And we happened to be studying something called stare decisis, S-T-A-R-E-D-E-C-I-S-I-S. It's a Latin term. And Professor Kennedy taught it to us. He said it was like a field of rocks, that if we wanted to know what the law was, under English common law, you walked out into a whole field that was full of rocks, and you started turning them over to look at the answer on the bottom, kind of like that little, what's that fortune globe that kids have when they're 8 years old? You ask it a question and you turn it over. And if it's the wrong one, then you turn it over again, and you turn it over again. And that's what we were doing in class with stare decisis. So we happened to be studying this affirmative action, and it was perfect, and I raised my hand. And of course he called on me, 180 people, but I knew he'd call on me. And I said, Professor Kennedy, I just don't understand, under this stare decisis idea you're telling us about, how you could have voted for affirmative action the way you did or did not vote. I don't actually remember how you voted today. And I said, you know, looking at this and this and this and this, these other 6 cases we had, it seems inconsistent. And I thought it was a really good question. Duh. The whole class went, nobody said a word. 180 people go, and I'm thinking, oh dear. He got so mad. He was so angry with me. He didn't call on me for 3 months, and he said, Miss George, we don't talk about current cases. But he didn't say that for about 30 seconds till after the class had time to recover, that somebody would ask that. And so you're looking at someone, who in this room knows what Myers-Briggs is? It's personality testing. Anybody here know what Enneagrams are? It's a Christian, ancient Christian personality testing. They're all different kinds of testing. What I found out much, much, much later is that the way I think is not the way most lawyers and judges think.
Wow.
Okay. Under Myers-Briggs, for example, if I had the blocks, I forgot to bring the blocks today. Janice has such wonderful kid blocks. They're little wooden blocks. There are 16 different personality types. So if you put, and they go whether you're introverted, extroverted, and they measure this. It takes you a couple hours to take the exam, and then you get your whatever you are, supposedly. Enneagrams are kind of like that too, only Enneagrams are sacred. But it's a real interesting way, especially for mediators, to learn about personalities and what motivates people and what frightens people and what moves people along. What I found in my studies is that there's this old University of Dayton neuroscience exam using Myers-Briggs personality types that it turns out if you line them all up, most of those attorneys and judges in America are in the top, these 4. You can't say the top 4 because there's no number assigned to them, there's no superiority, but they think in a certain way. For example, they naturally are born to think in a linear way. You will never find a ballerina in there. You won't find a poet. You won't find a basketball player. You'll find on this lineup, you'll find that the doctors and the nurses and the caring people and the social workers are here. And then you've got really great, you've got cowboys and, you know, way out there people who are experimenting on things and alternative thinkers, and everybody has different kinds of attributes. But this little area up here, and what you find is people who rise to judgeships, and this is what I wanted to do a doctoral thesis on, was to study them because they are the most rigid thinkers in America, and they are judging us. And so we have this little tiny, what, 1/3 millionth of a percentage of people who are judging us in court, especially in family law court, and they think differently. They have, I want to say, an aberrant way of thinking, but it's very thinking, and it comes to them very naturally. Linear is only one of those things. They made terrible bosses, by the way. I know of 3 Myers-Briggs psychologists in America who travel around and counsel at law firms because people with this really tight linear way of judgmental thinking, they think in black and white. So it's either black or it's white. There is no gray. There is no balance. These are the people that got in there, whether they got in there by politics, by election, which is not likely, or whether they got appointed. Let me tell you how you get appointed in New Hampshire. And I found that almost every state has a price, by the way. The last place I was New Mexico. Pay to play, that's what they call it.
That's it.
Pay to play. It's as low as $7,000 a month to the governor's chief of staff. In New Hampshire, it was pretty easy, and I was kind of wondering when I got divorced why I got invited to so many Eagle events. Anybody know what an Eagle event is? Oh, come on. No big rollers in here? 50,000 a year.
50.
Republican Party.
That's it. 50.
State. That's it, 50,000. And so what my ex would end up doing is he would contribute law services from our firm, and that gave him bonus points. So when he plotted for 2 years to get divorced, but he didn't want to have to pay anything, like alimony or you know, whatever our personal stuff that went on. It was all public. It came out in the Washington Post, the New York Times, the London Times. People, I told you, it was Oprah. I mean, it was the ugliest divorce you've ever seen in America, because I'm not the kind of person that kind of lays down and rolls over. And I was surprised. I didn't know I was going to be divorced. I didn't even know he was unhappy. Dang. I read about it in the Union Leader over the fold. They carried it, headlines. That's how I found out I was being divorced. And when he left, I thought, oh my gosh, he's having a breakdown. It wasn't like that, but that's what we have with this new legal system, where attorneys and judges with this tight mindset fashioned this club in 1972 to 1982, where they were forced to become bar members. But what that means, you think that would mean, oh, we have really good ethics. You don't. There's a loyalty to the clubhouse. The loyalty is just like a country club. I grew up backed up to a country club. I know what it's like. It's really fun. You go to the country club and nobody else gets to go, but you get, you know, you've got this own social network, and it was really fun being in the country club, but it's not fun if you're not in. And that's what's happened. We are now at the 50-year mark for every single state forcing every attorney into the bar. And what you don't know when you go take your oath of office is you take this oath of office to uphold the Constitution. I've got one over there in my purse. I carry the Constitution around with me. I'll tell you, the judges do not carry constitutions. And what you are not hearing, and I just went through a case where I am stunned to realize that the entire case, over 5 years, there was no rule of law. And now, you folks probably maybe don't realize what rule of law is. Rule of law, it's not just those rocks that you're turning over in the field. It's not just stare decisis, but it's part of it. We in America operate, except for Louisiana, and they ought to belong to France, but we operate under common law. Common law, there was 2 different forms of doing it, and they still have 2 different types of law in England. They have the House of Lords, which is imperial law, and then they have the House of Commons. Well, we kind of have that too, except we have the Senate and the House. But none of them are supposed to be lords. Let me tell you where the lords are in America. The lords are not the Hollywood stars. That's what you think. That's our royalty, right? American royalty is Hollywood. The lords of America are this 3rd branch of government who are now governing themselves. And every time you turn around, they'll say, what do they say? Trust us? Co-equal. Executive can't tell us what to do. We are co-equal. Don't buy it. I don't think they're co-equal. I think they still have common law. But what I've been studying, and what you've mentioned, and I fear for you. I fear for Michelle, because she didn't say the word contempt right away. But what I found in this case, that I went 3 years, 3 different judges, is that contempt of court is something to be feared by every single American who goes into court, which is why you never go alone to court. You think you're going in for a speeding ticket or a dog bite or gosh knows what, and you can be locked up. And you can be locked up because of this little pissy book called The Passive Judiciary, Prosecutorial Discretion in the Guilty Plea. Now, I knew, because I traced it from my treatise, that in some cases when you go into court, the judge is not the most powerful person in court. The prosecutor is. Do you know the prosecutor is probably the most powerful person in America?
Yeah.
They coerce so much. But judges are coercing too. Now, my brain is bifurcating, and we're going to go back to the second track of judicial discretion and contempt of court. And why everybody in this room, and anybody listening, and anybody going to court needs to be very, very, very careful. Being held in contempt doesn't just mean that you lose your children, for example. Or the example we heard yesterday, I think maybe we heard this morning, the woman who, living in her own house, of which her husband or ex-husband has no equity, he has no interest in the house. She arrives home, there's a sheriff, he says you have 2 hours to pack and get out or we're arresting you, and by the way, leave your children behind. Now, husband doesn't have those children. They go to a stranger. They go to a third person. I didn't believe this could happen, except I do, because I know that in New Hampshire, one of the cases I was approached to take was a woman who lost custody and was never allowed to see her children, and they were 3 and 4 years old, because they went to her in-laws, brother-in-law, sister-in-law. I also know of one. Now we're talking a married unit. Now we have a lot of unmarried units, which makes law even more complicated. It makes it so complicated. When everybody's cohabitating and having children, and they don't think about the what after. At least if you've been married, you've got legal rights, supposedly, that you're supposed to be able to go back and look at on the law book. But what I'm finding is that when you go into court, and I found this 15 years ago when I was still practicing law, is judges are not following the statutes. Judges are using their discretion. You want to know what discretion is? Give me another word for discretion. What's discretion?
Doing anything you want to do?
It's a magic wand! Anything I say goes. And what Michelle, I think, has run into when she was handcuffed to a wheelchair, now she's not wheelchair bound, handcuffed to a wheelchair for 34 hours and told to try a case after her client had been sent home. Her client isn't even in the courtroom. The judge recalls the case, handcuffs her to a wheelchair, and tells her to try the case. Now that's imperialism, if anything is. When I was arrested, it was imperialism. When Janice was arrested in court, it just drives me crazy. I know that the lady who sponsors this, one of the motivators she had, and I grilled her about that day when she went to court. It was a hearing on making a payment. The payment wasn't due until midnight that night. She didn't get to testify. The judge said not one word. That's all he said to her. He pointed his finger and said not one word. And the other side stood up and said she hasn't paid. And the judge said, "Bailiff, you know what to do." So you walk into court, and the first thing the judge says is, "Bailiff, you know what to do," which means somebody's been talking to the judge before the hearing was called. Well, that's called ex parte. Okay, so we all know ex parte is, you can't do that. No, bad, can't do that. So what? What this book, this dark side book, came out of is it used to be called Sneaky Judge Tricks. I developed, we've had to talk, but people were contacting me. We got together for a 2-day course, and I didn't even know what we were going to teach or talk about. But the women sat around, and everybody groused so much. Everybody there was an ex-wife of a judge, by the way, from all over the country. There was one ex-wife of a governor. We're called the Ex-Wives Club. We were the first Ex-Wives Club before, you know, NBC stole it. Anyway, there were 17 of us, and they were grousing so much at this restaurant that I just got up and I got a flip chart and I started writing down what they were saying. 29 things came up that day, and I realized that's a book. It was 29 sneaky judge tricks. It follows patterns. I don't care what kind of case you're in. You can be in an HOA case. You can be in a domestic violence case. You can be in a bank loan case. You can be in a construction case. You can be in a murder case. It doesn't make any difference. They do the same things in every case. But the easiest way to find the tricks are to look at judges' divorces. Because, as Michelle pointed out, you can't get divorced until you go to court. So the Achilles heel of finding judicial abuse in every kind of case is to study the judges' cases. Now they know this and they're sealing them. But that's like 101, that's in the first chapter. And what I've divided this up into is 8 chapters. And to make it simple, I narrowed it down to 120 judge tricks that happen in court every single day in any courtroom.
Wow.
I'll go with you.
Wow.
I go sit, sometimes I don't do it for fun much anymore, but I can sit there and I can start picking out these things. Now when you're in it and you're so traumatized, you can't understand what's happening to you. Especially when the judge is holding you in contempt and holding you in contempt, and they're treating you terribly. And okay, I'll get to the civil rights part, because I'm limited on time and I want to give you this contempt issue. It took me a long time. I've been coming for a couple of years to the Federal Civil Rights Summit, which is the last weekend in July in DC every single year. And it's not, they've never had judges. Last year was the first year they had anyone talking about whistleblowing in the court. And I had headed up the first panel, and they were afraid to put it on the marquee. They called it something more innocent than that. We now have federal civil rights for lots of different things. Thank goodness it came out of that 1964 Federal Civil Rights Act, and it was Martin Luther King. But it doesn't apply to people in court, I thought. Then we've had the era of the whistleblower. I'll never forget the year that 3 women were named Time Magazine Man of the Year. 3 women get to be 1 man. It was the Man of the Year edition, and there were 3 whistleblowers, and that was the year that I was a whistleblower. And I want to tell you, whistleblowers do not all get the cover of Time Magazine, nor do they get treated with respect. So now, fast forward to 15, 20 years, I'm still looking at whistleblowing and the effects of it. Because when you're in it, it is so dang traumatic. You go from, of course, losing your children. A lot of times, you'll see these cases where one side, it's a sum zero. There's never a win-win like you have in mediation. It's all or nothing. And the people with the biggest lawyers, especially if you have pro se on the other side, you end up being fleeced. It's 100% win. It's every asset. If it's a marriage, every asset goes to one side. And what I found, and I have to disagree with you, but I'm old, so I don't necessarily have current statistics, but you think 99% of divorce cases settle. And I disagree. I think what's happened is people who bully in a marriage become legal abusers. And the judges have bought into this. And they allow abuse to go to a very sophisticated level. Remember the 16 blocks? It's very sophisticated, educated thinking. It is, they're intelligent. I think also that there's a high degree of sociopathy there. I'm not kidding. Some people are smiling, but I think that we have more sociopaths involved in law, either as lawyers or judges, but you also find litigants. If they have money, they will use their money in the court system to do legal abuse. And so you end up more than battered. And there are several ways, and you can talk to me afterwards if you feel like you've been battered because you can't get out of it. It can last for years, easily 10, 20 years. It can last 2 decades, the legal abuse battering. Not only the cases, it'll last after it's gone. But if you want to identify it rather quickly, is I just realized that there's 2 kinds of harassment. And that's because I'm studying, what am I studying, Michelle? I'm studying the 1981 and 83 Civil Rights Acts to see if there is any way for pro se litigants to bring a class action or an individual action in federal court to get out of their own local state courts. If they can bring it in federal court, especially if they can bring it in one of the jurisdictions here that are sensitive to it. Baltimore's had these huge riots. Their court system is more sensitive. Pennsylvania is more sensitive. 2nd District, 1st District, DC District. As compared to some of the other districts, like 9th District and whatever, they are not so sensitive to civil rights because they don't face up to it. But if as a class, or if as an individual, if you can say I'm being discriminated against in court, How do you know? Well, let's go down the first initial steps. Part of it, sorry, I'm just like the guy that we videoed this morning, but this is a textbook for lay people. It's like Law School 101. One attorney read it in 9 days and wrote me the most amazing thing on Amazon. Read it. I mean, I didn't pay her. I didn't even know she was putting that up there. This is, for smart people, you can read this in 2 weeks and it's like going to law school.
Like the Dummy series.
No, it's more sophisticated than the Dummy series. Yeah, I thought about the Dummy series. And it's pretty wide-ranging in terms of topics and where we are in American society with this, because I think in addition to invisible disabilities that the ADA has, now there's some relief that can be had through that, but you still have to claim you're disabled and you have to follow the process. Dr. Karen Huffer has an amazing course at John Jay Law School in New York that you can take online. It's about $1,000, I think. But it's on invisible disabilities in the ADA in the court system. But what I want to know is, can healthy people go to court and when they're treated with great disrespect by the judge and by the attorneys, when they're cheated in court, when the outcome is so egregious that not only do you lose everything in your house, but they go after your reputation. And they stand up and say, we want a psych eval on her, Your Honor. We think she's crazy. And the judge goes, well, maybe we'll do that. And she can pay for it. I mean, it's nuts. How did we get into this system? So I traced it back to the 70s when that system developed, and I realized we have a country club system operating and self-regulating. They regulate themselves. You want to file a complaint about the judge, you may find out that the judge you're complaining about is the chairman of the judge committee.
That was mine.
Yeah, I know. I know, we all have that. It is possible to take them out. It might not be possible in your case, but you can pave the way for other people in the future. This is part of a movement, but I don't know how to get to the next level, which is to send them a wake-up call and say, okay, so you go into court and the judge looks very sternly at you and gives the room a lecture. Everybody else is represented by lawyers. You're the only pro se. But the lecture is about pro se and who you think you are, and we're going to follow the rules and blah, blah, blah. All you do is every time you go to court, you buy the audio. You get the audio and you tape it. And then you record it. And you're going to use that. So in my 5-year case, I had, what, 40 different hearings? And I'll tell you, it's tough to sit there and listen to them stand up and say, Your Honor, she's a liar and a cheat. And we know this, but we have to do this and this and this. And he says, okay, done. They call you names. Then they cheat on you. For me, about 70% of the time, the opposing sides, there were 2, none of them sent me any pleadings. But they certified they did. But they didn't send me any pleadings. So here I am as a pro se, you're trying to figure out how do you prove a nullity. It's like proving a lie. Carefully. You do it very carefully, and you do 7 times more work than any of those attorneys will. Now, in the meantime, they're all salaried. They're collecting $200,000 and you're broke. So you not only have to outthink them, and when you win, all you're getting back is to ground zero. You're just getting where you are. And so we can't do it alone. But if we can all do it, every time they call you a name, it hurts like heck. You write it down, you write who called you, you keep a notebook. You take notes on every single thing. Every time they say something wrong or do something wrong, every time you're arrested. And I will tell you the secret that I've heard from people, 2 people who have been wrongfully arrested in court. Like with Janice, when the judge says, bailiff, you know what to do. Do you know what the bailiff had been told? To handcuff her and take her out of the room. I think she was there 22 days. What I've heard from several people who've been arrested is the fastest way to get out is to fast, is to refuse to eat or drink. It's hard. 10 days out, you want to drink. 12 days out, you want to drink. 14 days out, you probably break down and drink. I think Janice told them she wouldn't drink out of a cup, they had to bring her a sealed bottle. The guy in New Hampshire, similar, he thought he was having a heart attack when they arrested him. He found a death threat on the seat of his car against his children. His car was locked. He drove into court, said to the judge, "You gotta help me, here's the death threat." And the judge had him arrested. And how many days was that? That was 10 days, I think. He also didn't eat or drink. And they get worried that they're gonna kill you, so they let you out faster. I don't know what to say about civil disobedience and civil. What I've been following is this thing called prosecutorial discretion, and I'm trying to trace it because we have a political movement in America which is called tough on crime, where politicians think that average citizens will vote for them if they overcharge, and that's what's ended up with so many people in America put in jail. And it's not just blacks anymore. It was. Now it's moving everywhere. We're all together in this. It's all kinds of groups. One of the techniques that they're doing is they will overcharge somebody who's been arrested. This is criminal area. So you've been arrested, they split your charge into 4 different areas. They break it up into little pieces, like fingers on a hand. They don't charge you with the hand, they charge you with 4 fingers. Yeah. And then they blow each one of them up. So when you go into court, you've got 130 charges based on these 4 fingers in this one hand. Yeah. And they scare the heck out of you. And they're allowed to lie to you, to get you to confess. So I think, I've worked with 3 different innocent projects. I find them to be remarkable, but so overwhelmed, often staffed by students with 1 paralegal, not even an attorney. So when I go in and I ask for help for people, they say, "Oh, you're so good, just do it yourself." And you're thinking, "Oh, I'm so tired." That's why I think if you don't have to invent the wheel each and every time, if you learn every time you go to court, you take somebody and you have them write what happened that day, and you get affidavits and you stay on top of it and you file it. You look for these slights. You look for a judge who says, "You know, I see the press in here. I'm going to put a gag order. Is that okay with you guys? Is it okay with you? Is it okay with you? Okay, a gag order." You don't say, "Yeah, it's okay." You say, "No, the press is my friend. They're here because I invited them." So then he'll take a break. You wait 4 hours. After the courtroom's closed, they'll recall your case, and the press is gone. And then they'll have whatever they were going to do before. But each time, and that's what I was wondering about when Michelle was talking, if she made a record. Each time you make a record. And the other thing I want to kind of wind up with is I want to say, you have to learn to trust in yourself and trust in God.
Amen.
If your intuition, if you're sitting in court and you feel compelled to say something, make a record. In this particular case that I went through last time, and it's just similar to what everybody else goes through, something moved me. I had filed and said, "I live far away, it'll take me 17 hours to get to court. Can I do it by telephone?" And the judge said, "No, you didn't follow Rule .107AD, subparagraph B." The other 2 attorneys then filed to appear telephonically, and they didn't follow the rule, but she said it was okay. So I had to drive my 17 hours, I showed up in court, and I'm sitting there and I'm angry with this judge, but you never, ever, ever, ever get angry in court. They have so much power. You're always respectful, always. I asked my sister once when you're listening to the tape, was I yelling? And she said, "You talk so softly that I can hardly hear you." And I said, in my mind I was yelling. But I said to this judge, I was kind of moved, and I just said, "Excuse me, Your Honor, would you just put on the record, this is a point of procedure, would you put on the record if you have had any contact with anyone in this case?" And she said, "What do you think you know?" And I said, I'm I'm sorry, Your Honor, I'm not accusing you of anything. I just wondered if you would make a statement on the record of, do you have contact with anybody? You know, there's like 7 people involved in this case. Do you have contact with them? Any contact?
I did that.
And she said, you tell me what you think you know and I'll tell you. And I said, I'm not accusing you of anything. I just want something on the record. And she said, I have had no contact with anyone in this case. I don't know anyone in this case. Blah, 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 blah. She was angry. And I said, okay, thank you. Sorry. And we went on with the hearing. It was an amazing hearing. They gave me a 45-day continuance because the other side had perceived that I was moving and they were moving in tandem. So all 7 attorneys were filing. And so, remember when I said you have to be better, especially if you're in pro se, you have to be 7 times better and work 7 times harder and be organized and have help and never go alone? Okay, so I got the continuance. The next time I go to court, they have this all worked out. They held me in contempt for not answering 3 contempts and an order to show cause. And I said I didn't know anything about it because they stopped sending me the mail. And the judge said, you certainly did know about it. They sent it to you. And the judges all stood up and said, we swear, we have a wonderful staff. We all sent her this stuff. So they all lied on the record. Okay, and I'm sitting there pretty confused because she now has 3 contempts and an order to show cause. And I don't have anything. I don't have any paper. I didn't get any paper. When I went back and studied it 2.5 years later, I realized the court clerk sent out a notice that said, all pending motions. Usually if you're going to have an order, you can get arrested in an order to show cause. That's why it's important. OSC. Usually if there's an OSC hearing, the clerk would say, notice of OSC hearing. And then I go, oh, I don't have any paper. I wonder what's being filed. And I would move to figure out what was happening. But I didn't. And so they railroaded it, and the judge said, I find that you received this. Oh, I know. They used an iPhone. This was iPhone evidence. So one of the attorneys whips out her iPhone Apple 6S, which she said was oversized and people made fun of her, but boy, was it helpful. And they showed a partial receipt, partial signature. No numbers on it, not attached to anything. And they said, this shows that she got it. Now remember, there's 4 pieces of paper out there. Here, and the judge took the iPhone 6S evidence as true. She found that I received all 4 pieces of paper from all 3 attorneys. What she did, and then she said she found that I willfully disregarded it and she held me in contempt. Okay, and then she ordered me to pay everybody's fees all around, blah, blah, blah. Next hearing we went, and I'm thinking, I didn't get any of that stuff, so I asked everybody to produce in discovery all their green receipts because I was supposed to be mailed, certified mail return receipt. The judge had ordered that a year earlier. And they didn't want to produce them. So we went into hearing, and the judge held me in contempt for emergency caption. This was the 3rd time she had censured me for caption. That means when you write a piece of paper, and you've got the caption on it that says, hearing for support. She said, that's contemptuous. And she held me in contempt a 2nd time, and then she said I couldn't have the receipts to prove that I wasn't in contempt the 1st time because it didn't go to trial. Do you see how convoluted it gets?
Yes.
Okay, so in the meantime, I have this officer, bless his heart, Rex Beard, what a great name. Rex Beard had arrested one of the parties. And it happened the same time that my event happened, and similar things crossed over. So I wanted Rex Beard to come and testify at trial. So I'm doing my pre-trial interview with this witness, and he says, you know, that judge, when she was a prosecutor, he said, I was so angry because she gave the most lenient sentence possible at law to this guy. And I said, what do you mean she gave the most lenient? He said, you can't get any more lenient. The judge that was forced to accept the prosecutor's recommendation, she's now a judge, she was a prosecutor. The judge was so pissed that he made the kid write a letter of apology on top of it because he felt like he hadn't been punished enough. So he's going to write a letter? We are talking DWI, stolen car, hit and run, 2 assaults on a police officer. And he gets to write a letter of apology? And by the way, he went to law school. They wouldn't let him out in time to go to law school. So I figured this out. I asked the judge to recuse, and we go into the recusal hearing, and she said, and I said, remember when you told me that you didn't have any contact with anybody, and it turns out you were the prosecutor and you gave the lightest possible sentence, and that's contact, and she said, I forgot. Okay, I forgot. We're all human, right? I forgot. So we go to trial, and long story short, she holds me in contempt again. And it's one of those sum zero, where the lawsuit is about 12 inches. But she finds me in contempt not on any of the issues. She finds me in contempt on some discovery issue at the last minute that wasn't a discovery violation. There is no such rule. She said there was a rule 37D, but she misquoted it. There is no rule. Anyway, so she awards them 22 inches. Now, the trial is about 12 inches. But she gives them the 12 inches, then she gives them 2 more, then 4 more, then all the way up to 22 inches. Thank you. And it's taken me a couple of months, because it takes time to figure this stuff out, to realize that this 5-year trial didn't use any common law. And it didn't use any statutory law from the state legislature. You know how they argue about all the bills, and we're here in Congress and they argue about bills? She doesn't use any of that. Everything was decided by discretion. So I'm now in the process of finishing the transcription on those tapes, which is kind of tough because it PTSDs you all over again. But I'm typing them all out, and then I start analyzing the heck out of each one of them, because I'm looking for civil rights violations. They go in 2 orders, and what I realized the deciding point was that contempt of caption. 3rd time she held me, I lost a motion because she didn't like the title. Now I'm in pro se in a state where I've never practiced, blah, blah, blah. I mean, I'm just like any other little old retired sheep herder lady. It's sheep ranch. And she's holding me in contempt of caption, but what I realized at that point is she was protecting the members of the bar because they're a country club. And it's so egregious that the bar members at the first contempt hearing had lied. Now, she's not allowed to keep their discipline within her courtroom. It's mandatory in the bar that if there is not even discipline, if there is a question of discipline, the judge loses jurisdiction and it has to be referred to the state bar committee. Now, some of the attorneys in this room have been through that state bar committee, and they know that when they do something that displeases the judge refers them because it's a punishment. But you get referred, and the disciplinary process can be very, very harsh. But from favored members of the court, like in this case, when the attorneys lied and said they sent me, if they sent me them, they would have had the little green cards that showed they sent it to me, but they didn't send it to me. Plus, everybody forgot that I got a 45-day extension, and the time hadn't run. So my first contempt of court, I was held in contempt 10 days before I was supposed to deliver. So there was no contempt. My second contempt was because I was trying to prove I was innocent of the first contempt, but she found me in contempt of caption. Contempt of caption.
That's crazy.
And then the third one, she said, you are so contemptuous and you are so disobedient. And she said, I'm going to do a nuclear sanction against you. I'm going to do, this is using a rule that doesn't exist. 37D doesn't exist. No, I'm going to do. I'm going to do the most egregious punishment. And she said all of this on the record, and she ranted for about 7 minutes, and I have found 4 minutes have been erased from that ranting. So now we're up on appeal, and the tape has been erased. The audio has been erased. So I put in motion after motion, and I've got affidavits up the wazoo, and I've got all these people writing affidavits that they heard her say that I committed criminal conspiracy to not turn over discovery before the last day of trial. It was an impeachment exhibit. Anyway, that I didn't have until the eve of trial. None of that makes any difference. when they want to find a solution, remember the blocks, the 16 blocks? They can think of anything. So I can give you 120 examples in this book, but what I'm doing is I'm trying to stimulate you to thinking in categories. So, for example, I have a chapter called Financial Tricks. And I have financial tricks up the wazoo because money is what this is all about. It's taking money from ordinary citizens and giving it to the country club members. That's why you're not going to find many bankrupt attorneys. I know my time is up, but I want to give you. That was footnote 1. The 99.997% of the 322,267,564 people in America in 2015. But we have one more. Attorneys have a cute way of referring to each other as brother so-and-so. To flatter Brother Jones in court, an opposing attorney will call him Brother Jones. There is no title sister that's parallel to this. See Trade-ins of the court. I'm looking for the hourly rate. Footnote number 26 on page 13. The average American earns $25 an hour. The average law firm, $342 an hour. That's from Mary Lynn Shivovicki, the other pro se person in Princeton, New Jersey. That was a quote from her. They make so much money an hour, but the judge is the one that is the gatekeeper for this. And what's happened because we allowed them to police themselves over the last 50 years. Remember, this doesn't go back to the Revolutionary War, it doesn't even go back to the Civil War. This goes back to the Vietnam War. This is a whole new idea that they self-regulate with no oversight. So the only way we're able to do oversight is if we do it one case and one case and one case and one case at a time. And they're killing us. We don't have the resources, we don't have
anybody to advocate for us.
It's not even that. They have the money on their side, they have the power on their side, and they get to self-regulate.
And they do it as their full-time job, and we have to do our part-time job,
and
moonlighting.
And they get paid for doing it. So these attorneys all rack in hundreds of thousands of dollars in my case, and if I win, I just get to keep my house. I mean, I'm at ground zero if I win. That's why federal civil rights is part of it. There's a second kind of federal civil rights, and I'll take two more minutes to talk about this because there is no financial incentive. There is some of these bills. Now help me with this. There's two bills, the Sardley-Baines, Oxley. Oh, what are they? Baines, Sardley, and Oxley, where whistleblowers get a percentage. So if you turn in this producer who's selling $7,000 toilet seats, those whistleblowers are getting rich. And there are law firms that specialize in those kinds of things. But for a pro se to get something, even if you win, you need a reward. Because you don't get to charge along the way, because it takes a decade or 2 decades or longer, and because right now they're going to claim we don't have standing. So we have to get around that whole issue of how do you bring a federal civil rights claim under 1982 or 1983, 81 or 83 against a court. And I think it's because the judges are politicians.
Human rights.
Civil rights. Okay, let's talk about civil rights.
Human
14th Amendment, what do we have? We have sex. We have race. We have
Religion.
Thank you. Religion. What else? Come on, guys. We have certain enumerated rights, but nobody is saying pro se rights.
Amen.
Now, some states, like New Mexico, have this little provision that they can't discriminate based on politics. And I think that's the hook. That if you can find that your state constitution relates back to the federal constitution, and that the judge office is political, that we may have a hook into looking at federal civil rights claims.
That's what Trump did. That's what Trump did.
He says clean this wrong,
That's what he did.
but I don't think he realizes there's a whole third branch out there.
He don't know
Yeah.
that. He don't know that.
He
He's not a career politician, but he's on the right track.
Yeah.
He doesn't know
He just needs to
about this
honestly
swamp, because
Yeah.
this
He doesn't.
swamp,
He doesn't.
this swamp
He's a good man.
is taking us one at a time, and
He's a
I'm
good
saying we've got to rise above our own.
Mm-hmm.
We've got to rise above our own and educate people across America
Absolutely.
that this is a much bigger swamp.
It's huge.
Yeah, we have more corrupt than the good people.
And because they get to regulate themselves. So if you file a referral for an investigation, you find that your judge is the chairman of the committee, or his buddy is the chairman of the committee, but nothing happens. The same thing with these lawyers. I mean, I have these lawyers that kept lying. They lied about 70% of the time in my case about delivering me the mail. The thing is, I think I've got them, because that intuition that day when something said to me, ask the judge if she has an affiliation, and she lied. And then when I catch her 5 months later, she says, oh, I forgot. Okay, somebody's gonna, maybe they're gonna deal with it, maybe they're not. Maybe they're gonna say, Carolyn Douglas, just go away. You know, you're bothering us. But I wanna tell you, because I do a lot of praying and a lot of thinking about this. The desert was really, really, really good for me. The high desert where it's so hot and sunny and it's so hot it hurts your eyes.
And Carolyn,
Yes.
be aware, God will not be mocked. God will not be mocked. Grace, justice, and love. Now is the time that God's people will arise. This is the time.
Saying God will not be mocked.
He would not be
And that's so profound, because what I'm seeing is we have these little courtrooms, especially out west. I mean, little isolated courtrooms where somebody gets to be a god over your life,
Mm-hmm.
and they're mocking God.
They-
Thank you.
You're welcome.